If you'd start in again, Doug, fine, yeah.
During the debates that preceded the passage of Taft Hartley Act, Senator Taft made the comment that he had heard references to good secondary boycotts and bad secondary boycotts, but that none of the testimony before the committee revealed any good secondary boycotts or any way of distinguishing between types of boycotts. I think I would disagree with the general conclusion here. I think there can be such a thing as a good secondary boycott. But this is good by my definition. Others might not agree with my definition. And in any event, I think for operational purposes, we have to have some sort of rule which on balance is most equitable. And I think under the circumstances of the present day, the most equitable or least inequitable rule here is to ban secondary activities, recognizing that in the process, some secondary activities that I personally might feel were justified would still come under the ban. On balance, however, this seems to me a much wiser rule than the converse rule of legalizing secondary activity or even of leaving it up to individual judgments in particular cases.
I'm interested, Doug, whether or not you would approve of any exclusions from the general rule. If you state the problem in an abstract way, and as a matter of policy say that you are opposed to permitting unions to bring pressure on Company B where the dispute is with Company A. If you make that your general rule, there is a danger that, well, not a danger, but I ask whether you have taken into account the following possibility. Suppose that Company A, the employees of Company A have gone out on strike in the course of a dispute over terms and conditions of work. Suppose that that Company A thereupon contracts out to Company B the work which would have been done by its employees, and that while the strike and picketing activity is going on, the work is being performed at another location. Within the abstract determination or statement of what constitutes secondary action, picketing of Company B might be thought by some persons to be secondary and consequently illegal. Would you make allowances or an exception for this kind of a case within your general policy? And if so, are there any other instances that you can think of where you might approve of pressure being exerted by the union, which is of the nature of secondary action, but due to special considerations ought to be permitted?
The one exception to the banning of secondary action that I would make is in this situation of following struck work. If Company A is struck and gets the work that it would otherwise do, or tries to get the work that it would otherwise do, done by Company B, then I think it should be perfectly proper for the union in Company A to urge the union in Company B not to work on the struck work. In other words, not to work on the work which would have been done in the struck plant. Here, clearly, you don't even have the innocent third-party situation. Employer B is no longer innocent. He has grabbed work or has had thrust upon him work which he would not otherwise have had. And I would make it perfectly permissible for the union in this one type of situation, following the struck work, to exert secondary pressure. This, I think, is the only exception I would make as a matter of a general rule of law.
Perhaps to clarify one other area, Doug, I might bring up the matter of the Kohler United Automobile Workers dispute and some of the activities that the auto workers have engaged in to win that dispute, to be the victor in that dispute. We are all aware that when the union was unsuccessful in effectuating a strike at the site, in other words, the company was successful in getting a sufficient number of replacements to be able to operate at or near capacity. The union thereupon sought to effectuate a boycott of Kohler products over the nation. The union district leaders in the various districts of the country approached other labor organizations. They approached builders and architects, asking them not to specify Kohler products in connection with installations and construction in which they were engaged. The union also appealed to the public at large to boycott Kohler products. Most of the appeal, of course, was first directed to the labor movement in the traditional channels of the central labor unions to carry out such a boycott. Now, in the background of the Kohler dispute, again, without going into all of its technicalities, unfair labor practices were filed, and the trial examiner has ruled that the company did engage in unfair labor practices. The National Labor Relations Board has not thus far so ruled, as to my knowledge. Assuming that the National Labor Relations Board did rule that Kohler had engaged in unfair labor practices, had refused to bargain, the union's case for effectuating some kind of a national boycott against Kohler products is somewhat stronger. I wonder if you might comment on the extent to which, as a matter of law, as a matter of policy rather, you would approve of reaching out to the markets of a particular concern by a labor organization in order to put pressure on the company to yield to certain union demands.
Here I think it's useful to recall the distinction between the consumer boycott and the producer boycott. To the extent that the union in the Kohler case attempted to put pressure on other workers or other employers not to work on Kohler products, not to install Kohler products. To the extent that this occurs, it would be a producer's boycott, and I would apply the same restriction on secondary activity here. To the extent that the boycott took the form of an attempted consumer boycott to get people not to specify Kohler products or to get householders not to purchase Kohler equipment, so forth and so on. Here I think I would permit this. In a sense, there's an inconsistency here between advocating that there be a ban on secondary producer activity and not a ban on secondary attempts to persuade consumers. But I think we get realistically into a different type of situation. When you get over into the consumer's market, there are many competing pressures to the union's attempt to induce a consumer's boycott. And again, just looking at the realities of the situation, it seems to me that perhaps a more even balance is struck if you permit both those people who are urging others not to buy Kohler products, and those people, and there are many of them, who are urging that Kohler products be bought. This perhaps is the best balance you can expect out of the situation.
Without encouraging too much repetition, there's one element in your remarks concerning the Kohler case that affords an opportunity to sort of pin the one matter down. You spoke of your feeling that a ban should be placed upon any pressure exerted by the union in the Kohler case against employers. Just to be sure that I understand your position without, or that there'd be no doubt about it, if a representative of the UAW approached a architectural firm and explained to the management that the dispute with Kohler was underway and requested that they not use the Kohler equipment, would you regard this as unlawful behavior under your policy?
This is a very difficult question to answer because it really gets right down to the borderline. In general, I would permit the union to request architects not to specify Kohler equipment, because I think the architect here occupies a role that is closer to that of being a consumer than to that of being a producer. Granted that this begins to get over into a very hazy area. If this were combined with any express or implicit threat that if the architect did specify Kohler material, he wouldn't be able to get anybody to install it. Here, I think then you've moved over to the other side of the borderline, and this, I would think, properly would fall under the ban.
Well, I think perhaps, Doug, we ought to just call a halt on that. But it does, as you say, raise this very difficult question. I don't know whether we want to pursue it now, but as you know, under Taft Hartley, the language of Taft Hartley has been so interpreted that pressure exerted against the employer directly is not a violation of 8b-4a, whereas engaging in strikes or inducing others to engage in strikes, that is, employees to engage in strikes, does constitute a violation. If your policy, when enacted into legislation, was a blanket ban, it seems to me to pose very serious difficulties in phrasing language which would permit the union to approach employers, as in the architect's case we just discussed, a language which would permit that and yet not allow the union to engage in implicit threats. But I think perhaps we will just won't develop it. We could perhaps develop that at another time. But it bothers me a good deal because I'm at a loss to know what language would achieve this precise result. It's legislation, experience with legislation indicates that trying to draw fine distinctions is very difficult.
Let me just make one comment on this. I can see where there'd be real problems in framing the legislation, but I don't think the particular case of the architect would cause special problems here. The architect could be defined out as not being an employer. He isn't an employer.
Mm-hmm. Okay, could you hold it, Marv? Maybe we'll get on to the hot cargo. Just get this figure. I don't see Marv yet. He shows up dimly.
Yeah.
Marv, Are you ready to, how much time have you got on that machine now? I wonder now, Doug, if we might not move over into the field of the hot cargo clauses, just to introduce this area. It is possible, as we agree by agreement, to achieve the results of secondary pressure. That is, the unions, and particularly the Teamsters Union and some of the construction trades, have for many years have had included in their collective agreements provisions which whereby the employer gives prior consent to refusal not to handle goods and refusals to cross picket lines at the selection and choice of the labor organization concerned. We may get into this in just a moment, the technical problem as to whether or not hot cargo clauses are not violations of 8B4A as it is written. But any discussion of a national policy with respect to secondary pressures requires that one take a position on the legality of hot cargo clauses. So I wonder if you might now set forth your views on a policy toward the legality or illegality of negotiated refusals to use or to work on or handle so-called unfair goods.
If we start with the proposition, as I have started, that secondary action should be prohibited, it seems to me that one conclusion emerges with crystal clarity from this, namely that clauses such as hot cargo clauses have to be declared illegal if the whole purpose of the ban on secondary activity is not to be circumvented. The hot cargo clause, or the circumstances leading up to the hot cargo clause, can be exactly the same as the circumstances of secondary action at a later date. The pressure is simply exerted at the time the contract is signed rather than at the time the incident arises. It may be argued that since these clauses are incorporated into contracts, which means that both the employer and the union have agreed to them, that the element of pressure is lacking. I think this is a very unrealistic way of viewing the situation. The element of pressure is always present in contract negotiations. And the employer accedes to a hot cargo clause, I would say always or almost always in response to some measure of pressure. Therefore, as I said at the outset, it seems to me that a ban on secondary activity requires automatically the declaration that contract clauses which would permit such secondary activity are in themselves illegal.
The standard Teamster contract contains the following provision, and I'm now quoting from the either the over-the-road or the local cartage contracts. It shall not be a violation of this agreement, and it shall not be cause for discharge if any employee or employees refuse to go through the picket line of a union or refuse to handle unfair goods. Now, very often in discussing hot cargo clauses, the part that gets emphasized is the refusal to handle unfair goods. But as we here note, it is common in these clauses to have prior approval for refusals to cross picket lines, again at the election of the union as to which picket lines they may with impunity refuse to cross. And I think it would also have to be conceded that even though there were to be a ban on contracts giving the unions the privilege of refusing to work on certain unfair goods, if it were legal to include in these contracts a privilege not to refuse to cross picket lines, that the same result might be achieved by another means. Consequently, do I understand you to say that in banning hot cargo agreements or hot cargo clauses, you would also illegalize agreements which give prior approval to refusal to cross picket lines?
It seems to me that the clauses which protect refusal to cross picket lines from disciplinary action by the employers have to be put in the same category with the ordinary hot cargo clause. If the ban on secondary action is to be effective, I say this with some reluctance because I can understand motives that might well, in particular circumstances, cause people to be reluctant or unwilling to cross picket lines. Here again, I think, however, is another instance of the necessity for a rule which will cause hardship or discomfort in some situations where perhaps it shouldn't be caused, but which on balance, in my judgment, will produce fewer inequities than a contrary rule would under the circumstances.
I know we've covered this ground before, but I'm going to go back to it in a recent issue. I think it was the issue of May for the year 1959 of the Teamsters Monthly Journal, commenting on a provision of the Kennedy-Irvin bill, which is now under consideration in Congress, and referring specifically to a proposed Section 8E, which would accomplish the result of which you now speak, namely to illegalize agreements which authorize refusals to handle goods as well as to cross picket lines. The union editorial designated the results of this policy as one which would make involuntary strikebreakers of the members of the Teamsters Union. Would you care to comment on that reaction to a proposal of which you approve?
Here, the definition of strike breaking is involved. In one sense, I suppose, requiring Teamsters to cross picket lines could be construed as requiring them to support the employer in the strike situation. I myself would not call this strike breaking. Strike breaking to me would mean actually performing the work which would have been done by the strikers. In a situation such as this Teamsters situation, this is not what is happening. The Teamsters are not performing the work at the struck plant. They're simply removing goods from the struck plant or taking goods to the struck plant. As I said earlier, this could be construed as a sort of support for the employers. I think a better way of looking at this would be that this simply means a limitation on what the Teamsters can do to support the striking employees. Again, I can visualize many situations in which my sympathies would clearly lie with the people who refuse to cross the picket line. But taking the broader picture, and particularly looking at the possibilities of complete stoppages of flows of goods and material, in this broader picture, I think probably the best results would be achieved if there were this ban on secondary activity, including a ban on refusal to cross picket lines.
Doug, we don't have too many minutes left, and I think that perhaps we ought to try to wind up just with the tape that we have here, and I think that gets us about. But I wondered just in the last minute or two whether I might just broach a problem. Again, we've agreed that this can't in any way be regarded as a final version this discussion might take. But just to get it out here now, in interpreting Section 8B4A of Taft Hartley, the National Labor Relations Board has run into some very thorny questions where the classification of the particular action as to its legality or illegality is a thin line. Take a case like the Pure Oil case. There, a union having a dispute with Standard Oil threw up a picket line around a dock in one of the West Coast ports. Pure Oil Company used the same dock facilities, as you know, for its operations. The Pure Oil employees did not cross the picket line. Now, on the question as to whether or not the presence of the picket line constitute an inducement of the Pure Oil employees to engage in a strike in violation of Taft Hartley, the board held that the action of the union of the Standard Oil employees was not in violation of Taft Hartley. This view has been criticized by some observers. I was just wondering, in a factual situation like that, how your policy would work.
Well, I think somebody has to make the factual determination here as to whether the purpose of the picket line was to influence the Pure Oil employees not to go through the picket line. The board, rightly or wrongly, made the factual decision that this was not the purpose of the picket line. I'm prepared to go along with the board's finding of fact on this, in this particular case, and would conclude, therefore, that this was not secondary action. Now, the Pure Oil employees did refuse to cross the picket line. It seems to me here the remedy lies with the employer, and if he is permitted to take disciplinary action against his own employees, this seems to me adequately to cover this particular situation.
Well, we perhaps could talk on as long as the tape holds out, but this question which you now raise as to, I take it that you would find that the action of the we can continue on the Marv, how much do we have left on that tape? About 3 minutes. All right, we'll just use up the 3 minutes and then we're going to quit. The refusal of the Pure Oil employees to cross the picket line would itself not be a violation of law under your policy. That is, their refusal to cross the picket line
would not be a violation of law.
Would not be a violation of law.
Right.
But the employer would have the available to him disciplinary action if they so refused. I conceive of one serious problem as to his right to discipline such employees. If the law is otherwise left as it is, and the only change in our Taft Hartley Act that we are presently considering, say, is dropping the ban on secondary boycotts as it is there stated, and including a ban of a more general nature, such as you have described, whether or not a concerted refusal to cross the picket line on the part of the employee, a union representing the pure oil employees, would not be protected activity under Section 7 of the Act. And if you wish to give the employer the power of legally disciplining his employees, whether or not some other changes in the Act might not have to be made.
I don't know that any changes in the Act would have to be made. I think the board has in the past protected certain types of concerted activity. I don't know quite how to put this. The protection of concerted activity, as visualized by the Wagner Act and the Taft Hartley Act, to me, is a protection of the right to organize and all that that implies. It is not designed to give the unions added strength on substantive issues. I think the board has, in many cases in the past, stepped over that borderline and has protected activities which are primarily of an economic nature on the theory that in the absence of protection, there would be discrimination in organizing or maintaining an organization. I put this very badly.
I understand what you're driving at, but as I understand what you're saying, therefore, is all you feel is necessary is a reinterpretation by the board as to what constitutes concerted activities, and confining one's interpretation of concerted activities to instances where it has to do with organization. And this